Why? Very well. Who is the person responsible? Who is the person responsible? No. Who is the person responsible to give that report? Fantastic. We have it on 22nd video link. Ask him to be present at 10:50. Very. Then when? 22nd. Waistline. It is people is being harassed. Is the public not being under harassment because of the pipeline? So let us have it something early before these vacations. 21st. Get your 21st. Okay. At the request of Mr. P. Nayak, the learned counsel appearing on behalf of the GMC, the matter stands adjourned to 22nd of December 2023, on which date the Commissioner, GMC, shall apprise this court as to what steps can be taken to stop the public health hazard, as was duly reflected in the order dated 2011-2023.
Matter is infrastructure.
Infractures, Mr.
P. Sharma.
P. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition, taking into account that the writ petition has become infructuous. Taking into account the above submissions made by the learned counsel for the petitioner, the matter stands dismissed on withdrawal. Full stop. Interim order, if any, stands vacated.
Wait.
Oh, that one.
Yes.
Done. It has been done.
Not our name. As per the allotment.
Okay, now this has been done, so nothing remains.
No one. There is Lordship will kindly find page 39 second four.
Your entire prayer is that. Why should I look into other things?
No, Pandit,
No, Mr.
Pala.
See your prayer at page 16.
This prayer, my lord, is in terms of the page 37. Page 37 is
Yes.
the order passed by the Chief Secretary, my lord, for allotment of the person to the direction of the Honorable Apex Court.
Yes.
The page 39, my lord, you kindly find.
Yes, then
Second portion, Guwahati Development Department shall provide minimum for required funds if necessary for the development of the plot with shaded market, etc. So until, my lord,
that is not what you have asked for.
Lord,
That is not. No, if they are don't allot, then you can very well approach.
allotment has already been done to the GMC. Now, GMC, my lord, if your lordship allows me,
Mr.
CT
Kaushik, your prayer is limited.
No.
Matter ends there. Okay. I will give you that thing. Wait. The in pursuance to the order dated 7/11/2023, in pursuance to the various orders passed by this court on 21/8/2023, 22/9/2023, 8/11/2023, and 17/11/2023, Ms. M. Bormon, the learned counsel appearing on behalf of the District Commissioner, Kamrup Metro, have placed an instruction issued dated 8/12/2023, wherein it has been mentioned that the land in question, that is a plot of land measuring 3 katha 10 lachas covered by Dag number 1069 of village Pamohi under Ramsorani Moja, have been already allotted in favor of the Guwahati Municipal Corporation for setting up of the Maskwa fruits and vegetable wholesale market. Full stop. It has been also mentioned in the said instruction that the that a necessary record correction have also been made in respect to the said land in favor of the Guwahati Municipal Corporation. And the Commissioner, Guwahati Municipal Corporation, was also intimated to utilize the allotted land within 3 years for the purpose for which it is allotted, or else it would automatically revert back to the government. Full stop. This court have also taken note of the Jamabandi in this case, the Chita for the surveyed village, and the remarks which have been mentioned therein. Full stop. Taking into account the above, as the land in question have been allotted in the name of the Guwahati Municipal Corporation, the relief which has been sought for in the instant writ petition has been duly redressed too. So accordingly, the instant writ petition therefore stands disposed. The said communication so placed by Miss M. Borman is kept on record and marked with the letter X. Before parting with the record, this court, however, finds it relevant to take note of the order dated 11/5/2018 passed by the Guwahati Development Department, wherein there was a by the Guwahati Development Department, wherein it has been mentioned that the Guwahati Development Department shall also provide the minimum required funds if necessary for the development of the plot with shaded market area, etc. Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner, submits that in view of the allotment order making it clear that the utilization has to be made within a period of 3 years, the respondent GDD, Guwahati Metro Development Department, as well as the JMC, is therefore required to do the needful in terms with the order dated 11/5/2018. Taking into account the above, Mr. S. Bora and Ms. M. Borman, appearing on behalf of the respondent, submits that the said action, that necessary steps would be taken in terms with the order dated 11/5/2018, as well as also that the said respondent authorities shall also do the needful in terms so that the said land can be utilized for the purpose for which it has been allotted. Taking into account the said statements, this court observes that the said respondent authorities shall do the needful as is required, for the proper utilization of the land in
Lordship mentioned as wholesale market.
what?
Lordship mentioned as wholesale market. It should be retailer. In fact,
it is given in the wholesale or retail.
Communication, my lord, they have mentioned wholesale, but the rectification of the land record, it says, my lord,
It has been given for setting up of the Masqua fruits and wholesale vegetables wholesale market.
But your lordship will find the correction, the land record correction. Say Paikari
What do they say?
retailer. Paikari. SMS or board pack.
Why would they see the document is kept on record and marked? It is mentioned as wholesale.
In the communication.
But otherwise it is
a retailer. And in the allotment, my lord, it is written as Paikari.
Yeah. That's retail market will लिखी हाँ it is, however, that line लिखी Miss M. Borman, the learned counsel, learned junior government advocate, however, submits that it was inadvertently written as Masqua fruits and vegetable wholesale market. It should have been Masqua Fruits and Vegetable Retail Market.
Probably.
It is a lot.
Yes, what is this?
My lord, I have filed an affidavit as per lordship order. My
Oh, yes. Yes, Mr. Gogoi, have you seen this reply? Hmm? Your address is Megmalar Housing Complex.
yes, my lord.
And this is what?
No, my lord. This is
Yours is Megmalar.
no. My lord, some problem, my lord, regarding my lord, the issue of identity card and the ID. In the address of the earlier, she was staying in her sister house. So I have mentioned categorically, my lord. And that particular day, my lord, she was also present in the flat, my lord. But police has not taken shown presence of her, my lord. Now she is staying with her son, my lord. And regarding my lord, payment of rent, my lord, till 2020, she already paid, my lord. 2017, my lord, paid to the department, my lord. Thereafter, when they refused, she used to pay, my lord, in the court. So now she is also ready, my lord, for payment of the year. In the after year 2020, due to COVID and my lord, her illness, my lord, could not able to deposit, my
Huh?
deposit. After 2020, my lord, it could not able. I mentioned, my lord.
Mr. Counsel, tell me one thing.
Sir.
Now you are saying that you are residing in building number L, unit number 17 under ARHS scheme.
But I have given address here.
Understood. Now, haven't you mentioned in your affidavit somewhere, if I remember,
Sir.
huh?
Yes, ma'am.
Which affidavit? Today?
Lord,
No, earlier. Earlier, she says that my son used to reside there,
Yes, ma'am.
not me, because I stay with my somebody.
My lord, due to illness, sir, my lord. She is
Huh?
62 years lady, my lord, due to illness. Sir.
Then
That now she is staying in the
you have come back
yes, sir.
because of the litigation.
Uh, not the litigation, my lord. Her sister also expired.
Huh?
Died. Her sister also died.
Then when did you return back?
My lord, she is staying, my lord. Yeah.
Who?
Two-
Since
2000
when?
my lord, as per
Because I'm telling you one thing.
Sir.
If you're making a false statement out here,
Sir.
it will be very serious for you,
yes,
for
my lord,
that lady.
I have asked my my side. She's saying, my lord, I have stated also in paragraph 4, my lord.
What is that Islam fellow doing? Sorryful Islam, or what is he doing out there?
My lord, he is as the caretaker of
Huh?
caretaker.
When?
My lord, earlier one Ajmal Hussain driver was there, and driver
What
left.
was the driver doing out there in the house when you were staying there? Why do you need a caretaker for the house when you are already there?
He is, my lord, practicing music, and for the purpose of music, my lord, he goes somewhere, my lord, event, my lord.
So,
So sometimes this person is there.
huh?
This Ajmal Haq, and thereafter, my lord, sorry.
We will ask them to lodge a criminal complaint.
Whatever my client stated, my lord, categorically stated. Regarding rent, my lord, I will pay, my lord.
I do one thing.
And earlier notice was, my lord, in the name of one Ritupun Deka, my lord. You have challenged that one.
Whatever may be.
I have submitted also memorandum before the authority. Page 26.
And how did you get the show cause notice?
My lord, from my son, man.
Huh?
From my son. My son was staying there when he received.
So they gave you just with you this show cause notice.
Sorry.
You didn't take any receipt. Huh, Mr. Gogoi? Huh? That is what I'm saying. If the notice was issued to somebody else, then hmm. And if you are depositing in the court, go and file a suit there. Why should this court look into all this thing? And if you want to throw him out, throw him with due process.
Yes.
And there's nothing.
There is the observation of this court.
The instant writ petition has been filed by the petitioner challenging an eviction letter dated 26/7/2019 issued to one Ritupon Deka on the ground that the said Ritupon Deka was an unauthorized occupant of the flat in question, which was allotted to the petitioner. From the facts mentioned in the writ petition, it reveals that by an office order dated 9/6/2006, the respondent number 2 had allotted a residential unit by number EWS, building number L, unit number 17 under rental housing scheme at Bhetabara to the petitioner at a monthly rent of rupees 650. Full stop. It further reveals from a perusal of the petition that there were various defaults in payment of the rent, for which show cause notices were issued. However, subsequently, another show cause notice was issued to one Ritupon Deka on the ground that he was in unauthorized occupation of the said flat. And it is under such circumstances the petitioner have approached this court by filing the writ petition. It reveals from the records that by an order dated 2/9/2019, this court had issued notice and pending disposal and pending notice, the status quo as regards possession was directed to be maintained. Thereupon, the matter was not listed for a long time. On 29/11/2023, on 15/11/2023, when the matter was listed, Mr. T.R. Gogoi, the learned standing counsel for the respondent number 2, submitted that he has received the instruction and would like to file an affidavit. Pursuant thereto, on 28/11/2023, an affidavit was filed wherein it was mentioned that in terms with Rule 15(1)(p), 15(1)(p) of the Assam State Housing Board Rules 1976, if an allottee who is authorized to occupy the premises ceases to occupy the premises for a continuous period of 14 days without the previous permission in writing of the board, the permission to occupy shall cease forthwith. It was mentioned that in view of the fact that the petitioner was never in possession at that point of time, and it was one Ritupon Deka who was in occupation, the said notice was issued. It was also mentioned that the petitioner had concealed the fact that her allotment was already cancelled by order dated 18/9/2017. Further to that, referring to it was Rule 15(1)(f) of the Assam State Housing Board Rules 1976, it was mentioned that the petitioner herein could not have assigned, sublet, or otherwise transferred the possession of the premises or any part thereof to any other person. It was also mentioned that just prior to the filing of the affidavit, and an inquiry was conducted wherein it was found that one, what is his name? Somebody else was in possession, na? Soriful Islam was in occupation of the said flat in question. Next. On 29/11/2023, when the matter was listed before this court taking into account Safiqul Islam, SAFIQUL Islam, was in possession. This court taking into account the said affidavit, and the state affidavit directed the officer in charge of Hatikau police station to make an inquiry and submit a report on 30/11/2023 at 10:15 a.m. Accordingly, a report was submitted on 30/11/2023 by the SI, by one SI, bracket P, Kulodip Mojumdar of the Hatigao police station, wherein he has mentioned that he had made a personal visit at the flat in question and found the son of the petitioner along with one Soriful Islam residing at the said flat. Along with the said report, the Aadhaar card of the said Soriful Islam, as well as the petitioner's son, was enclosed. When the matter was listed before this court on 30/11/2023, this court, taking into account the said report, granted an opportunity to the petitioner to submit affidavit in respect to the said report, as well as also to bring on record the rent receipts paid in respect to the flat in question for the period during which the instant writ petition has been pending. The record further reveals that the said affidavit was duly filed by the petitioner, wherein it was contended that not only her son, along with the said Soriful Islam, was present on the date on which the inspection was carried out by the police officials of the Hatigao police station, but she was also present. It was also mentioned that the petitioner had paid the rent till December 2020, and thereafter however, she clarified that she had paid the rent directly to the Assam State Housing Board till November 2017, but thereafter she had approached the upon approaching the authority, and as the authority had refused to accept the rent, the said rent had been duly deposited before the court in terms with Section 5(4) of the Assam Urban Area Rent Control Act 1972. This court, upon hearing the learned counsel, this court have duly heard the learned counsels for the parties and have also perused the materials on record. This court have also taken note of the Aadhaar cards of both the petitioner as well as the son of the petitioner. Surprisingly, the Aadhaar cards mention some other address other than the address which have been mentioned, other than the address mentioned in the, other than the address of the flat in question which have been allotted. This court also finds it relevant to take note of that the allotment was cancelled as far back as in the year 2017, and the said allotment order had not been cancelled and not have been put to challenge. And this very aspect of the matter has also been not brought to the attention of this court by attention of this court. It is also noteworthy to mention that in the instant affidavit in the affidavit in reply filed today, there is a mention that since 2017 the rent had not been accepted, but there was no mention as such in the original petition. These aspects clearly show that the instant writ petition therefore suffers from suppression of material facts, inasmuch as various vital material facts such as cancellation of the allotment order, the non-payment of the rent, non-receipt of the rent by the respondent number 2 since 2017, as well as non-payment of the rent during the period from 2019 to 2020, and non-receipt of the rent by the respondent number 2 since 2017 have not been disclosed in the writ petition, which were vital for adjudication of the instant writ petition. Taking into account the above, this court therefore dismisses the instant writ petition on the ground of suppression of material facts.
My lord, one thing I make clear, my lord. There are facts that it is stated, my lord.
In view of the in view of the above finding and analysis, the respondent number 2 shall be entitled to take recourse to, shall follow the due course of law for the purpose of eviction of the petitioner.
My lord, para 5, I have stated, my lord, regarding they have not agreed to receive the rent, man. This is mentioned.
Now you are saying,
No, my lord, in writ petition. In writ petition. Para 5, lord.
where?
Thereafter in para 8, my lord.
Huh?
In para 8, my lord.
What? What about the other one? About the cancellation? Cancellation?
Cancellation, my lord, I have not received, my lord. I have not received any cancellation. And my lord, lordship may only see one thing, my lord. The Chocos notice also some overrating, my lord. Page 13, my lord. Regarding my lord, the payment of rent, my lord, I have stated
You have not challenged the cancellation.
that's correct. So far, my lord, regarding
Next.
oblige.
My lord, kindly come to paragraph 9 of the definition. Page 5. Somewhere in the middle, my lord, accordingly a regular inquiry by dated 24/5/17 was initiated at this directorate. In course of inquiry, letter dated 4/1/18 was sent to some officials to depose in connection with the regular inquiry. Final report of RE number was sent to the government by letter dated so with a request to close the. Further, it is to be mentioned that petitioner has not received his copies of the same petition to the MRI.
And where are the other inquiry?
Yes. My lord, regarding one inquiry, if a lordship will kindly take the affidavit filed by the CID, my lord.
This was filed by whom?
It was filed by Obindra Kumar Nath.
This affidavit is filed by Gopindra Oya, Superintendent of Director of Vigilance and Anti-Corruption.
That is different. Earlier, it was by CID, my lord. First,
Page
page 9 of that affidavit.
Konindra Kumar Chaudhary.
Yes, no, my lord. Konindra Kumar Nath.
No, Konindra Kumar Chaudhary. No, that is by I am discharging my duty as the Superintendent of CM
Yes.
Special Vigilance.
No, Superintendent of Police CID. In fact, there are 3 cases.
That is one. This is CM Vigilance.
Respondent number 6.
I
I'm referring
denied
to the
that, yeah, would
affidavit
you-
filed by 6.
Submit a complaint petition is to ensure against.
Last para, my lord, page 10. My lord, by that affidavit, they have only stated that case has been referred to CID. Now, CID's affidavit is by respondent number 6. Page
Is-
10.
Today,
No, my lord. The
one affidavit is of Gopindra Kumar Nath.
yes, that one, page 10 of that.
That is,
This is by CID.
respond number 6. That
Yes.
is of 2018.
Yes. And it's the last para, page 10.
Is ascertained that the allegation
During
submitted
inquiry,
by the
yes,
complaint
no
is
truth, the allegations could not be substantiated as information highlighted in the complaint petition is not found and genuine. Allegation is found to be manipulated and based on. So this was by CID. In between, my lord, there was one final report which submitted by my lord, in case number GR case number 887 of 17.
Where is it?
Yes.
This is final report.
Final report by my lord, in GR case number 887 of 17. This was by South Salmara.
What does it say? Very difficult one. It's a final report. There's nothing.
Ah.
No case under 406, 420, and 506. And
so,
you
my
are for
lord,
whom? So all arises because of one person
one complaint.
by some Mustafa
Yes.
or Mustafa or
Abu
Mustafa.
Mustafa Sheikh.
Oh, yes. 12. Who is appearing? The instant writ petition was filed by the petitioner. Challenging three proceedings initiated against the petitioner on the basis of complaints filed by the respondent number 12. The three proceedings were: number one,
My lord, CID inquiry number 86 of 2017.
no, let us first go by
My
this
lord,
one.
kindly come to that affidavit.
No, RE number
Regular
35.
inquiry.
No, this is number one.
Ah.
RE number 35 bracket 5 2017
Yes.
pending before the Directorate of Vigilance and Anti-Corruption Assam
That
Srimantapur.
is in last
Got-
point of time.
Number two, South Salmara Police Station case number 203/2017 registered under section 406, 420, 506, 34 /34 of the Indian Penal Code. And where's the third one?
My lord, it says CID inquiry. If your lordship kindly comes to page 11 of the affidavit.
And
It starts at page 6, my lord. Submission of inquiry report in connection with inquiry number 1. Page 6 of that affidavit.
okay. And but that you have not challenged.
No.
This
Already-
one.
Because my lord, it was already before even we filed
Okay,
this.
and yeah, and two. It further reveals from the record that apart from the two other proceedings, mentioned proceeding, there was also another proceeding before the CID. What is the CID full form? What?
A criminal investigation department.
The Criminal Investigation Department of the Government of Assam, which was numbered as inquiry number 86/17 pertaining to cell des Roman 21 CID Assam. In the same proceedings before the Criminal Investigation Department bracket CID Assam, a report was submitted on 1/7/2017 that the allegations made in the complaint had no truth, as the allegations submitted could not be substantiated, as the information highlighted in the complaint petition was found to be incorrect and not genuine. However, in spite of the said report, as there was a continuation of two other proceedings, the above noted two proceedings was put to challenge before this court by filing the instant writ petition. It is also, however, relevant to take note of that during the pendency of the instant writ petition, The South Salmara Police Station case number 203/2017 registered under section 406, 420, 506/34 of the Indian Penal Code was closed on the basis of a FR being submitted that there was no case made out under 406/420/506/34. It further reveals that during the that it further reveals from an affidavit filed by one Pobindra Kumar Nath, who is serving as the superintendent of police, Directorate of Vigilance and Anti-Corruption, Assam, dated 18/12/2023. That on the strength of the petition filed by the respondent number 12, a preliminary inquiry was conducted by the directorate by P/E number 56/17 dated 3/5/2017. Subsequent thereto, the inquiry officer submitted an inquiry report suggesting for a regular inquiry. On the basis thereof, a regular inquiry by DVN NAC gap R/E number 32/5 2017 dated 24/5/2017 was initiated by the directorate. In course of the inquiry, letter by number DGVA/RI/2018/74 dated 4/1/2018 was sent to some officials to depose in connection with the regular inquiry. Thereupon, the final inquiry report of the regular inquiry number 32/5/2017 was sent to the government by letter number DGVA/RE/2023/9926 dated 11/12/2023 with a request to close the inquiry. Mr. Kane Chaudhary, the learned senior counsel, upon instructions submits that in view of the closure of the various cases as well as the inquiry, nothing further survives in the instant writ petition. In that view of the matter, the instant writ petition therefore stands closed on withdrawal. So you have got the 62,500.
Yeah.
Huh?
No, my lord, it is already settled, your lord. 62,500.
Settled.
Yes, my lord. This
What,
is,
which
this
one
is
is
the
not
first
settled?
policy of my father, your lord.
Huh?
And I am for the another one, your lord. Page number 30. Here 1 lakh with 8% interest per annum. And after quiz my acceptance data, your lord. Okay.
Yes, madam, why this was not paid? $34. Yes. Huh? There was no school.
But my lord, there is a school, my lord. Panikati Pratmik Vidyalaya, lord. This is the photocopy, lord, of the state school. And it was established on 1990, lord. Utalguri PTAT.
So any other document is there about your age? Your father's age?
Other yes, your lordship, death certificate is there. But,
Death certificate cannot be age
death
certificate.
certificate.
Then
Then I have to PAN card, Aadhaar card, it may be there, lord. But I have to submit. These are not on my file.
2014 no Aadhaar card was there.
PAN card is there.
PAN card will be there.
I have to submit then, my lord. I think it is not in my file, lord.
Now what is your terms of the policy? Of huh? So it is a wrong information furnished by a person. Then only. Now if he can very well provide a particular document, shoot, then I think you can take care of it. You get your instruction, I think that is the best way. Instead of going into and finding out whether in the Panighati that college was there, or- isn't it?
Yes, my lord. But we have the photocopy of the state school here.
Huh?
We have the photocopy of it.
Of
The
what?
state school. Photocopy of the state school, your lord. Your lordship. Panikati Pratmik Vidyalaya.
You have that photo?
Yes.
Very well.
Established on 1990, your lord. The headmaster was issued the state certificate.
No, find out any other government document. You had a PAN card or anything to show that age. Then only if it could then be said that it was a right information and they are appropriate.
And when the
Mr.
police,
So and so, the learned counsel appearing on behalf of the petitioner submits that he would may be given some accommodation for the purpose of filing an additional affidavit, bringing on record any other document which would show the age of the father being duly recorded by a statutory uh, uh, recorded. To list the matter again after the winter vacations.
Masuk.
Right. The
Hmm.
petitioner is a D voter minor. Against his name, whether D has been put, and no reference has been made by the.
Why the devoter matter before the single bench?
It is a my lord, not against the judgment of the tribunal. It is not against the judgment of the tribunal. My lord, on yes,
Your name was there till when?
1997.
So 1997 you were a devoter. And what made you realize today in 2019 that you have to file a writ petition after 19 years? Why?
My lord, first my lord, I tried my best to correct the.
Huh?
I tried my best to correct, but it was not entertaining.
No, in 1997 you have not been able to vote.
Yes, that is
Then why do you need the right to vote?
going to 80, 90 years.
Huh?
Possibly 90 years.
Then what is the age of the petitioner?
Possibly my lord, 85 at the time of filing.
Then
1997.
is he alive?
Alive. I verified alive.
What is his name?
Javed Ali.
So it first caught the attention in the year 1997.
Right.
Who is appearing for whom? Huh? Who you? 3, 5, and 6. That's how it is. I live for 3, 5, and 6. And who appears for the superintendent? Miss Judas. You are appearing for whom? 2 and 7, so and so. Hello. Union? No union. Yes, that your union. It's the SK meeting. Huh? Order. Itu kali constituency. What is that constituency?
Johnny
আৰু SP
Corpet.
বৰপেটা আৰু 40
No, it is 44.
44
That is
এই জনিয়া এইটো spelling চাই লিখো হা জনিয়া to the competent foreigners tribunal
Corpet.
reference be made in dispose of
Okay.
জনিয়া কৰি দিব হা More than 3 years have passed by. This is where? Where is the land?
Village,
No, where is the land? Village.
now
Huh?
town, sir. Town, sir.
So what does the government have to do? Isn't it the deputy commissioner who can do it? Because on the last occasion, the revenue department has placed before me another thing that in respect of certain matters, it is not required to be sent to the government. The deputy commissioner has the authority. Isn't that, madam? Hmm? Isn't it? If it is only certain matters which can be gone. Therefore it is not required. That is what they are. An instruction was placed before this court by the additional to the effect that government-wide communication directed the proposal be examined and so and so and so. Not in this case, but in some other case it has been favored. Hmm? This is the 17.5 lesser.
Yes.
I remember.
17.5.
Where is the land? Town.
Lechipara, sir. Under Lechipara town.
The town can it be given without the approval of the government? Now have you placed it to the revenue department? Okay, 13/12. Okay. Then we will wait after vacation, fixing out on 22nd. Pursuant to the order passed by this court on 24/11/2023, Mr. J. Hendrick, the learned counsel, appearing on behalf of the district commissioner, Dhubri, have placed an instruction dated 14/12/2023, issued by the additional deputy commissioner, district commissioner, Dhubri. From the said communication, it is seen that pursuant to the directions for resubmission of the proposal, the subdivisional officer civil Bilasipara had submitted the settlement proposal again on 13/12/2023. Ms. P.R. Mohanto, the learned counsel appearing on behalf of the revenue department, shall apprise this court on the next date as to what is as regards the status of the said proposal so submitted. List the matter again on 29th of January 2024. The said instructions so placed by Mr. Hendrick is kept on record and marked with the letter Z. Yes, Mr. Bhuya.
My lord, in fact, my lord, last 2-3 occasions, my lord, there is a direction from this honorable court, my lord, that whether in future there is such scheme is operating or not. My lord, what has happened, my lord, under the Chief Minister Samagra Brahmo Union scheme, my lord, a self-help group of particular village area is entitled to a tractor with all, my lord, its machinery for the purpose of enhanced the cultivation. Now, my lord, as per the guideline, my lord, we are entitled and have also been recommended for selection. But suddenly, my lord, when the select list had been published, this private respondent has been given the said tractor, which originally belongs to us. When we
Belongs to?
belongs to our self-help group, as per the recommendation of the select list.
Hmm.
Now, my lord, and then what has happened, my lord, during the course of the hearing of this petition, my lord, it has been come to the light that tractor has already been allotted and they are utilizing it from last 2-3 years. Now that cannot be, my lord, altered or revert back to us. That's why, my lord, this honorable court wanted to know that in future, is there any possibility of providing the tractor to us? An instruction is sought for.
Okay, 1 week we shorten it, 22nd. List the matter on 22/12/2023.
Well.
On which date Miss S. Bora, G. Bora, appearing on behalf of the Agricultural Department, shall apprise this court as regards the instructions to sought for by the order dated 12/6/2023.
Obliged. May I?
Hmm,
Sir, relating to contract payment matter. And
payment of what?
my lord, a work, my lord, collected the waste in the Dibrugarh town, my lord, and percent in a work order, my lord, at page 31. The bills were submitted, my lord, and part payments were made, my lord, but
Who is paying for the Dibrugarh Municipal Board?
yes, yes. Okay, sorry.
Huh?
Last occasion, they took time for filing affidavit.
Okay. None appears on behalf of the respondent numbers, appears on behalf of any of the respondents. Then why you are not saying that? Getting out. Huh? No, for one. Then what is your stand? Is he entitled to the amount or not? Okay. None appears on behalf of the respondent number 3 and 4 on call. Full stop. In spite of the fact, and full stop. Further to that, the said respondents have also not filed the affidavit. Full stop. As a last opportunity, this court grants an opportunity, this court grants a final chance to respond number 3 and 4 to file the affidavit. List the matter again on 5th of February. Full stop. It is made clear that if no affidavit is filed, this court shall dispose of the instant writ petition on the basis of the materials available on record.
Obliged.
5th of February. Yes. What is it?
The personal hearing in between the parties is going on over the, as per the order which is the 10/2/2021,
What?
10/2/2021, court has passed an order that we made a proposal in respect of the export obligation. We give a some. So on that basis, now the hearing is going on. The affidavit they have submitted where they said that they defer the matter for this purpose. So again, the hearing. So because regarding the export obligation, we said that we are a new. The present petitioner, what happened, Lordship? The proposed government has give some tax benefits. So the petitioner purchase a machine from the foreign,
What?
from the outside of the India,
Import.
imported. Yes.
Import what?
Yes. A coagulation machine, it is called coagulation machine, about 3 crore machine. So that machine, regarding that machine, when that exemption was the
Why should this?
the exemption was lifted out. Of
Why
that
should
part.
this court at all entertain this type of petition?
That in that
Why?
part,
Mr. Medi? Off? Then why should this court entertain this type of petition? You have avenues, go there. You say you have 3 crores. You have purchased a machine. Oh, you have good money. It is not for this court.
no, that's why
Then
that-
go there.
as per the order of this court, that hearing part, they are deciding that part because has the kindly see lordship, that order. So they kindly see that lordship only one line, that is, or in the order kindly see the order.
Order
10 to
dated?
2021.
Huh?
10 to 2021.
That is a notice.
With
Next
regard-
day, no coercive measures will be
Sir.
taken.
Yes, with regard to the petitioner's extension of block-wise extension of EOP for 2 years, 50% of EO fulfillment through major partner CG Foods India Private Limited and its associate in respect of. So we said that the present petition is not is a new because all the
Whether it is new or old, what is this court going to do?
partner will no.
Where is the
partner-
order? Impugned order is where?
That is lordship in page number.
Hmm?
70 or page number 81. I am telling that two
Page 81.
70 initially lordship.
Huh? You don't know?
Yes, lordship.
Page number what?
Page number 7070. Annexure
17.
no only 70.
Huh?
Only 70. 70.
70.
Yes.
18 2. 18 12.
18
Re-
12 2015.
This
Where is
has reference to your representation dated so and so requesting for re-export of capital goods in respect of so and so. Your request was placed before the ceremony in its meeting held
So
on so and so.
Your request
The
was
decision
placed
of the
before the
committee
EPCG
is
committee in its
reproduced
meeting held
below.
on chairmanship Sri
Committee deliberated upon the case and decided to
Children,
reject the
director
request
duty
of the
is
party
reduced.
for re-export of the capital. They may, however, pay customs duty and applicable test interest thereon, and thereafter export the it. So your case seems to be that you exported something, imported something,
Yeah.
and you want to export it back. Now they are saying that you want to do it, but you have to pay the customs duty.
Yeah.
That's the case.
Later on, what kindly see in the page number 80, page number 83.
Huh.
Then after we made a proposal, that what? Page number 83, below portion. We request your good self to allow us to fulfill the export obligation as follows. Extend the block-wise overall time limit to fulfill the export obligation by 2 years up to November 2. Allow us to fulfill at least 50% of the obligation through our major partner, CG Foods India Private Limited and its associate.
Hmm.
These entities are capable to complete export obligation within the extended time frame. There is no adverse effect on the revenue of the government, stated as follows. Then Lordship in page number 84, they replied back.
Hmm.
This has reference letter number so and so requesting extension of blockwise EOP extension of 2 years, allow us 50% fulfillment to a major partner, CG Foods India Private Limited and associate using so and so. You are hereby advised to submit the following documents, information director to consider the case. Copy of the valid export obligation, so and so. So Lordship, that thereafter we submitted page number 85.
So there is a personal hearing given and you have not appeared.
No, I have appeared.
No,
No, appeared. Lordship,
As per
can
the
you see?
affidavit.
Affidavit or no? Ah.
Oh. The parties are not ready with the matter and which matter stands adjourned to be listed after 6 weeks.
The interim order.
You know what? This court is not satisfied with your sum. Should I reject it? The interim orders passed earlier. We issue rule. Better off. Because you are not interested. The government seems to be not interested. I'll record that. When they filed the affidavit on 11/12, why you are not interested? You have mentioned in your affidavit out there, you should have been more ready with the matter. Then you got a copy of the affidavit. Then why? No, in your affidavit, you categorically say that you have given him the opportunity of personal hearing and he has not appeared. Finally, paragraph, it is pertinent to mention that in the PRC meeting decided to call for the matter was offered hearing, however, no one hence the decided to defer the matter. Then, so now if on one hand he is saying about the personal hearing, why should this court at all entertain this type of writ petitions? And I am not getting why I am not getting your submission in that regard. Why? Isn't it necessary for you to submit that when he has now approaching out there for personal hearing, why should this court at all entertain this type of writ petitions? Then is it for this court to put it in your mouth about this type of submissions? Very sorry state of affairs. Leaves the matter after 4 weeks. The interim order passed earlier shall continue. That's state of affairs. So what? Your submission should have been on one hand, these people are he's asking for personal hearing, and if it is a question of personal hearing, let the decision be there, taken out there. And if there is any opportunity out there, if he is aggrieved, he can very well approach. That should have been your submission. I don't understand why you are not making that type of submission. Should I put it out and make you clever for that? Do whatever you like. Yes, what happened on 8/12? Nothing happened.
Lordship, in this matter, the auditor served upon other response.
Hmm.
Now, this particular award that has been passed by the insurance ombudsman, and the award is at page 12, where they have approached the private the ombudsman with the new policy, with by giving the old policy rules and regulations, where the executive clause was different, whereas it has been notified to them, and they have been presented, and the same has been awarded to them without any proper reason. Your Lordship, it has been in the page 13 is the award where it has been clearly brought to the knowledge of the ombudsman that 419 pertains to is not a hazardous thing, but they have represented that 419 is something different, under which their claim has been the new terms and policies has been renewed in the year 2016. The same has been notified to them. The communication in email has also been annexed therewith. They have accepted the same. They have never put any objections to it. Every year the same has been renewed. So later on, when in 2019 they admitted they are claiming the same under the rules and regulations that have been provided in the earlier family floater plan, the year 2000 before 2015.
This is a claim for what?
The medical,
Hmm?
medical field,
Medical insurance.
medical.
Why you are not giving it to him?
Because it doesn't come under the purview. Because it comes under the exclusion clause. Your Lordship may kindly peruse 419 of the new terms and policies.
Where? Where is
Page
it?
number 18,
Page number?
1818.
Yes.
There is the exclusion clause in new terms and policies. There's 419, 4.19. It
4
says
point.
19.
Where is that?
It's a page 20. Clearly
49.
mentions-
Oh, page 4.19.
Yes, sir.
For age-related macular so treatments such as rotational field, quantum magnetic these are excluded.
Yes, sir. The PECT has been clearly mentioned here. And they were also advised for the same that they did not want to, they do not proceed with this. But they have not put any hit to it. They have done this, they have come under this clause, but they have submitted the rules and regulations that has been submitted that in the before 2015, the terms and regulations was different. And that is also I have submitted in page number 15, Your Lordship, the old.
So your submission is out here that his policy which he had taken, it had the exclusion of this particular disease.
Yes, sir.
And he had this particular thing, and as such, you had repudiated this 1,61,000.
Yes, Lordship. And moreover, this has been communicated to them. They have shared
Where is the communication?
Lordship. Page 27.
Yes.
Himanshu Jain has replied that can you please issue the policy documents and confirm that the policy is successfully renewed in the year 2018 itself?
Hmm.
And moreover, their list of in the 23 also page, they were informed about the same of the change in the policy in 9 December 2016. Again, in the page 26 itself,
What is this EECP? What is EECP?
this has been mentioned as enhanced external counter pulsation.
Huh?
Exactly,
What is this EECP?
it is too hard.
Enhance external counter pulsation. Now you say that it falls under this, so you have repudiated.
Yes.
Now, where is this claim? Let us see.
He is claiming under the page number 15, Your Lordship, is the old rules and regulation that has been submitted before the court. In the page number 17, here 4.19,
Okay.
it comes
Kindly come to page 13, down below.
under 30.
The decision of the insurer to repudiate the claim as per 4. Is not sustainable because the clause 4.19 incorporated in the policy issued to the complainant refers to only hazardous like scuba diving and there is no mention of ECCP.
Yes,
Whereas this particular thing was very much there in that policy. It was there at page 4.19, that clause.
4.19.
So that is your submission.
Yes, it was the earlier policy, but it doesn't come under the new policy because they have renewed the policy every year. They have claimed in the year 2019. It has changed in the year 2016.
Yes, Mr. Jain. I got the understand. That I am not concerned. No, Mr. Jain, I am not concerned with that. I am only concerned is whether clause 4.19 excluded ECCP.
I have been 30.
I'm asking you whether this particular document at page 15, Annexure 2, is a part of your document.
They have subsequently changed it. And
When?
they have placed not well before the first.
But it is a false claim because in the award itself it has been mentioned that the insurance we have taken a plea under this. It is clearly in the award in the 18 point.
So kindly, I say unless that they have.
Mr. Jain, kindly come to page 13. Kindly see paragraph 18B. The treatment of ECCP was not covered under the policy as per so and so. Why you are saying that it was not placed before the ombudsman? But why you are saying that it was not placed before the ombudsman?
They have placed.
I am not answering this, whether this was the policy which was issued to you or not.
No,
That-
because they were.
You didn't issue.
It has been issued, Your Lordship. The communication details has been annexed here with the email has been sent. The complete annexure has been given here. Here's the 8j.jvnit is department to Himanshu Jain, Your Lordship. He has replied with the email ID also. There are list of communications, Your Lordship, starting from the page 21. They cannot deny it.
Their read what they have. They have alleged email for 9 September.
Now, when did this thing happen? For the purpose of which you are asking for medical? In our view, there.
Of their
I'm ready.
they have said it for 9 but they have rejected from 7 March. That's the
Understood, but that is why I asked you, when did this incident happen?
and page
Mr. Jain, kindly come to the point. When did the incident happen for claiming? So this was whether it was that if it was a case of it, they did it in the month of June 2016 by sending the policy on December, then out obviously it would have been a case.
They have written in the, kindly tell you 24 days.
I've seen it. These changes are effective from 27.
In our, there are new benefits, features added as per the demand. They have written that they have added new features and benefits, not any exclusion.
Exclusion has been mentioned there.
It is there.
Is there?
Where is the policy? Are you saying that this was the policy which was used?
My lord, kindly take my affidavit.
Hmm.
They have the page 49.
Hmm.
Page 49.
Hmm.
When I have transferred my point,
Hmm.
they have given they are regularly doing the same.
Hmm.
The same terms and conditions which I have, they have taken 2019.
Hmm. Hmm.
And page 49.
Hmm.
Is the police need when it was transferred to Guwahati and same police. It is there in 2011. But in page 4.19, page, the same condition is there. Same condition. Without any changes, page of my affidavit. They have to meet when I am. But 2013, 2020, they have been with the same transaction without any.
This cannot be claimed, Your Worship, because email ID has been, they have asked for the policy, the email as well as the hard copy.
Email have
The-
answered that only some new features have been added.
They have never objected to the policy. They are also free look policy for 15
Where
days.
is my
They have
consent?
never put any objection to it.
If they have changed, they have given the whether that if any,
Mr. Jain,
they cannot give any evidence that they have been.
no, are you not making the payment of renewal? Are you not accepting the contract?
So they have not made the policy.
Then why have you not asked for at any point of time?
How could they apply
They
for
are
it?
there, and they have mentioned that only some new features have been added. Not any. They never include that they are.
And what is this type of policy? It starts with 4.2, page 15. What are the earlier period?
It was before 2006.
Why you are putting it 4.2? It starts with 4.2.
Uh,
Is the Oriental Insurance Company in such shambles that it doesn't afford for another 4-5 pages?
But it can be done. But I have
It can't be done means on this ground should be dismissed. What is this 4.2? You are putting it on the first page itself.
But I have the original copy.
There's no stay. Stay, I'm removing it. Make the payment immediately. We'll consider later on.
But
This is this.
this is the
You pay it from your pocket. You are the lawyer, you pay. It is your mistake. Why have you done in this? And who has certified this? What is his name? Certified to be true copy without the full copy. What is this type of filing? Who is this person who has done it? What is his name? Some Ahmed. Who is he?
Yes, Amrit.
Huh?
Yes, sir. Fine.
Then
Sir, sir.
you are certifying it to be true copy, which is the half of it. And the entire issue revolves upon this particular policy, and you are saying that this is the policy which was given to him.
This is the old,
You are not putting the entire thing.
this is
Call your manager.
no, Lord,
tomorrow.
This is the old, it is the
Call your manager tomorrow.
This is the new, not
No, Mr.
They
Counsel.
are coming under the new policy.
Call the manager tomorrow. We want him on oath as to say this particular thing that this is the policy. You can't take the people for a ride. And that too putting it only half pages, not the entire. What is the wrong with you putting it from 4.2? Why the earlier portion is not there? Wouldn't this be a case of suppression of material facts?
No, Lord, sir, not at all. I have-
Absolutely. Why you have not put the entire policy? What is there on the earlier pages which is there?
I have the copy with me, Your
The
Honor.
Ombudsman Authority, which otherwise knows about these things, they have categorically decided that this was never a part of the policy. And it seems to be very tenable when he has enclosed the entire policy, which you have not. For some good reason, you have not enclosed the first period out there, which would have otherwise shown the period when it was issued.
It has been completely changed from the 2016.
How do I know?
Lordship, I have given the original policy of the.
Where is the original policy? It starts from 4.2.
Lordship, that is the
Yeah.
old policy. That is the old policy.
Are
that
you
doesn't
saying
come-
from page 15 it is old policy? You say give it on oath that it is the old policy, then now new policy, therefore
New
4.2
policy
would not
comes
be
on the
applicable.
later page, Your Lordship. That
You
is
ask
the-
your person to be present in the court,
It-
whoever it is. Ask your manager, whoever it is. We'll talk to him.
it is-
This is not the manner in which you keep on filing the writ petition. Goodness.
Page 18 starts with a new policy under which they have claimed the same. So we have not given the earlier policy, that doesn't come into play, Your Lordship. That is the old policy that doesn't come into play. Now the new policy that they have claimed under, I have put the entire policy there, starting from the general exclusion.
Annexure 3 is the general exclusion. Now, this Annexure 3, he has been given another policy. Look here. What is the policy which you have given it to him? The Happy Family Floater Policy. That policy
That is the
4.19
earlier policy.
says
Then
something
it has
else. He has
been
given the entire thing.
2016.
We'll definitely believe him. Not
Happy
the one
Family-
by which you have given half a portion of it.
HFF policy was the earlier policy. HFF 2015 is the new policy.
We are concerned about 2019.
Yes, sir.
2019, which period? And this is the policy from 2019? Happy Family Floaters Policy? Which was the policy issued to you in the year 2019 when this policy was in existence? Why are you putting that from the period from 2017 5 2020 to 18 5 2021?
They have given the same which I got the very beginning. They are giving
Mr. Jain, why you are not also pointing out the proper policy? The incident happened in the year 2019. Why you are not placing that policy?
time they are not giving the they have given the well, they what they are the year 2020 was transferred to what they have
Where have you mentioned the policy have not been issued before the ombudsman? Show me that. That the earlier policy was not issued. Show me that. No, forget about the order. Where have you mentioned out here that the earlier policy was not issued? Or you don't have the policy from 2019-20, but from 2020-21 you have it?
they have not mentioned about the period. It won't complete the transaction without the date, without the period. Only in the renewal they have given that policy. Because I have taken it only because it was transferred in 2020.
We are not concerned with 2020. We are concerned with the period from 2019. Why you are not bringing that document out here?
Because they have
You
never-
don't have that.
they don't have- they
Mr.
don't have-
Jain, do you have that?
Yes,
Where is that? Why you have not enclosed that?
but nobody mentioned the period.
Not necessary. Show me that paper which connects it. That there was this happy for this was the very policy which was issued there. Put it on that on an affidavit. Why you are not putting out there right the proper thing? Because his only issue is at that relevant point of time, this particular 4.19 reads as this. Whereas for you, 4.19 were related to scuba diving. That's all. It's a very simple issue. He imposed a cost of 50,000 upon you for misleading the court and not filing the entire thing.
Lordship,
Upon you, lawyer.
Lordship, I do not want to any misleading the court.
No, this is. I have imposed. You go and
I-
file appeal before the Supreme Court or whatever. I'm imposing a cost upon you, 50,000. This is not done. You have to be more careful filing it.
Okay.
No, Mr. Jain. You are a senior lawyer. You should be knowing what to be done. Why you are not enclosed the main document?
that
This matter needs, I think after hearing both of you, this matter needs to be adjourned to be listed in the year 2029. That is the best way. Absolutely. No. I had taken the matter for urgently on the last occasion and because of you. But this is what the state of affairs is. Not done. I am issuing rule in this matter to be heard in the month of 2000, in the year of May 2029. Because of the fault of the client, of the lawyer. You. Because of you. What stops you from putting that particular policy before this court? Upon hearing the learned counsels for the parties, it transpired that the issue involved herein is as to whether clause 4.19 of the policy, of the health policy, which the petitioner had taken, or which the respondent had taken, the private respondent had taken, was included the disease of enhanced external counter pulsation bracket EECP. Full stop. In the general exclusions. It appears from the records that neither the petitioner nor the respondent have enclosed the relevant policy of that particular year. Full stop. The policy which have been enclosed by the petitioner is a part of some policy showing the general exclusions. It shocks and surprises this court in the manner in which a company by the name of Orient, a company that is the Oriental Insurance Company Limited, have filed the instant writ petition by not including the entire policy, and only a part of some papers pertaining to the policy have been enclosed. This also shows that there might be a case of suppression of material facts. However, taking into account that the respondent, private respondent, have also not enclosed the relevant policy of that year, this court is not inclined to impose exemplary cost upon the petitioners or the counsel. An opportunity is given to the parties herein to file the relevant policy of that particular period. That is for the year 2019. List the matter again on, let's have it on 1st of April, being the April Fool Day for both of you. What? January? Absolutely no. That is, I've already given 1st of March 2020. Mr. S. Dutta, appearing on behalf of the PNRD Department, seeks for an accommodation for filing the affidavit. He submits that the affidavit has been sent for vetting and would be filed within a period of 7 days from today. List the matter again on 22nd of January. In the meantime, the petitioner is to advise would be at liberty to file their reply.
Let us go till the bill dated.
You have a
Nobody
status
said.
quo?
They are not putting the
Next.
Okay.
Got the money?
Yes, yes, sir.
to close it.
Whatever the principal amount I have discovered, the except the interest for
Interest you won't get. You go and file application. The award has been passed. So if you have agreed by any amount, then you go there. There's a method by which this is done under what provision?
uh, section 24 tab close to lot. The
No.
section
Under
84
under what provision this acquisition was done? Yes, Mr. Borbuzeri.
section 9 lot.
You have got 86 lakhs.
Yes, sir.
No. Under what provision the acquisition was done? Lekho.
Note
Mr. Asidas, the learned counsel appearing on behalf of the petitioner submits that the petitioner have already received the amount of rupees 86 lakhs 13,601 as the under the, for the acquisition of the said land. He, however, submits that the said amount is inadequate. This court have also inquired with the learned counsel appearing on behalf of the respondents as to under what provision the said land has been acquired. It has been brought to the attention of this court by Mr. R. Borbuzeri, the learned standing counsel appearing on behalf of the revenue, that the said acquisition has been done under the provisions of the Assam Requisition and Acquisition Assam bracket, Assam Land bracket, Requisition and Acquisition Act 1964. Taking into account the petitioner herein would be therefore at liberty to file appropriate application under section 12 of the said Act of 1964 before the Deputy Commissioner, before the District Commissioner. Which one?
Dorong lot.
Dorong. Seeking a reference to the court. It is mandated, it is observed and directed that in the circumstance the petitioner herein files an application under section 12 seeking a reference, the Deputy District Commissioner Dorong shall make the reference in accordance with section 12 of the Act of 1964. With the above, the instant petition stands disposed.
If what aspect is about it? The section 80 of it.
What?
Section 80 of the new fair act of it. So here what the interest portion after the 1 year help to file land as equity.
Mr. Counsel, you have all these things, raise all these things before that court. Understood? Not for this.
Yes.
That's it.
Pass out.
Yes, Mr. Chaudhary. You're there?
But on the last occasion, there is a direction to file affidavit.
Last occasion is that there was no representation for the petition. 6/12/2000, and there is no representation on the petitioner on call. Then,
No, after this filing of the affidavit was there.
yes, you have filed the affidavit. Then what else? You must have, after 5/12, you must have therefore seen the affidavit side away.
No, that affidavit I'm having lost him on the last.
Then what else do you want? No. Mr. S.P. Chaudhary, the learned counsel appearing on behalf of the petitioner submits that the affidavit, after pursuant to the receipt of the affidavit, you would like to take instructions. This is the matter after the winter vacations.
It is the last case. My lord, in this case, I have received an affidavit in opposition on 12/12/2023, my lord, on
Hmm.
behalf of the newly imputed respondent, sir.
Hmm.
I require some time, my lord, to file our reply.
What is this interim order?
Interim order, my lord, there was a note, order passed against the present petitioner to stop construction, my lord, from the receipt construction to remove and demolish the illegal construction.
Mr.
MHO.
Mr. M.A. Chaudhary, the learned counsel appearing on behalf of the petitioner seeks for an accommodation for filing a reply to the affidavit in opposition filed by respondent number 6, 2 and 6. Affidavit in oppositions filed by the respondent number 2 and 6. Full stop. List the matter again in the month of on 5th of February 2024. In the meantime, the affidavit, the reply shall be filed. Interim order passed earlier shall continue till then. You kindly give your names. I don't put anybody's name. I only put his name because he's making a submission. If you want, I can put your name as so and so has submitted that his name may be incorporated. You want that? That you ask the registry to.
Okay.
You give your name in the slip, they will put.
I thought,
I'm vacating the interim order.
I thought, Mr. Ken Chaudhary sir was supposed to answer.
Vacating the interim order. You seem to be not interested.
No, we have filed a rejoinder.
What are you filing your rejoinder? That was filed long time back, 1512.
I have filed my rejoinder.
You're not interested.
No, my lord. Only at the last one.
Yes, Mr. What do you have to say? Should we dismiss the petition? Very well. Let's dismiss it. Yes, what is your submission? Why shouldn't I dismiss your petition?
Mr. Ken Chaudhary sir was
So?
supposed to answer. I am not prepared. Sir.
You don't prepare me. You take a very big risk before this court.
He was supposed to answer. But
So?
some people can. Otherwise, I was informed. Chaudhary sir will surprise them. But all of a sudden, he tried to get
Can't help it.
as a last one. Immediately after.
Is this interim order prejudicing you? Because they filed some contempt also.
Yes.
I remember that matter also has been taken with it.
Here,
No, I remember those. I remember this fact because this was moved before me. So I remember that. So I'm therefore saying, see, on one hand they are asking because you were only allowing 8 people out there or something to that effect. 10 people out. So then they say that after the disposal of the said petition, nothing remains. You couldn't have given it for these 10 people any further. So that is on which they are approaching this court. Termination. The reason why you are saying out there, because the fact that if you are going for termination, there has to be that existence of that fact, which is there in the clause to be there. Where is the clause fact? That is the issue out here. But that is not as per the agreement. That would you impose in terms with the another provision, it's a different thing. See, there are two aspects. One is a contractual obligation. But whether the contractual obligation is actually superseded by the statutory obligation, that is the question. Because as per the contractual obligation, there has to be an existence of those facts. That is on the basis of which he has come. He said that the existence of those facts are not there, for which how can he issue this particular thing or exercise the power out there? So if the exercise of the power or exercise out here has been done on the basis of something which is not existent, wouldn't the concept of malice in law come into picture?
At that point,
Anyway, why should I make them clever? Anyway, the learned counsel for the petitioner seeks for an accommodation in the matter. Full stop. It appears on the 15/11/2023 also. The learned counsel for the petitioner has sought for adjournments. As a final opportunity taking into account that there is an interim order. The matter stands adjourned to be listed again on 1st of February 2024. The interim order passed earlier shall continue till then. It is made clear that no further opportunity shall be granted. Yes, you have filed the affidavit. Oh, given?
Noted, noted.
Huh?
Noted.
What note here? 5,48,393.42 paise. How much? You go there. Go there.
I will go there now. I have come to know that it is paid.
Chalo. We do one thing. We have it after the vacation. Get the information whether the check has been bounced or not.
Yes, yes.
Huh? Huh? Mr. J. Roy, the learned counsel, senior counsel appearing on behalf of the ASTC, submits that an amount of rupees 1 lakh have already been deposited before the member MACT 1 Motor Accidents Claims Tribunal, Guwahati, on 14/12/2023. Further to that, a draft is being prepared, has already been prepared today, of an amount of rupees 4,48,393, which would be deposited before the member Motor Accidents Claims Tribunal without fail by tomorrow. So, taking into account the above, list the matter again on 5th of January 2023. 5th of January. In view of the above submissions and the documents which have been placed before this court during the course of the hearing, this court dispenses with the filing of the affidavit as directed by the order dated 29/11/2023. Till the next. Okay, let us have it on 4th. Not necessary. We are only one team. 5th. Let it be on 5th. Because let's finish up this matter. Unnecessary contempt has been pending from 2018. The last order helped. I told you, Mr. Mehdi. Last occasion only I told you. Now you'll get the money. Yes. What is this? Why the matter has come? Itu gimana?
In this petition,
48 তো ইয়াত নাই দেখোন লিষ্টত. Yes, why the matter has come up?
petitioner filed this petition seeking direction from this honorable court to
As
provide
per the Lozima Court's order, service of notice upon 5 are deemed to be complete. Moreover, no affidavit has been received from the state respondent. Late order. Okay. Service being complete, list the matter for admission after the winter vacation. Hmm.
Filed an IF for amendment of writ.
Huh?
Amendment of writ petition.
Why?
So if the reference to the order dated of the honorable.
Amendment of the writ petition, main one.
Yes, sir.
Uh, How many writ petition? All.
Yes, five lordship, five writ
In
petition.
all the writ petitions.
Yes.
Okay. You have objection? No objection. What is this amendment you are seeking to bring?
Lordship in, regarding writ appeal number 160 of the 17th lordship, there are some, we have some increase the lordship cost cycle.
Okay. এখন মই ডিক্ৰিপশ্যন দি দিছো বাকী মানে একে একে বেলেগ বেলেগ অৰ্ডাৰ হ'ব প্ৰত্যেকখনত বেলেগ বেলেগ অৰ্ডাৰ তাত মই অৰ্ডাৰ দি দিছো The instant application has been filed by the petitioner seeking leave to amend the writ petition, taking into account. Why? Why do you want to implead? Why do you want to amend?
Lordship in, amended lordship cost cycle validity of the notification number such dated such as issued by the government of Assam, Annexure D.
Taking into account that in view of the judgment passed by the division bench of this court in MS Durga Krishna Stores Private Limited versus the Union of India and others, dated 4/5/2018, it has become necessary for the purpose of amendment in the writ petition. This court have duly considered the amendments which have been sought for in the writ petition and in the application, and is of the opinion that the same would be necessary for the purpose of proper adjudication of the writ petition. So accordingly, further to that, the amendments which have been sought for would not change the nature of character of the writ petition, the writ proceed. Accordingly, the amendments which have been sought for in paragraph number 3 of the application is allowed. The petitioner is directed to file the amended writ petition, amended copy of the writ petition by 22nd of December 2023 before the registry of this court by answer and by file the amended copy of the writ petition by serving an advance copy to Ms. So-and-so. By serving advance copy to the respondent on or before 22/12/2023. So I stands post. Itu protected elected. All this private. Yes. What is this? Admission stage, I will, it should have come.
Yes.
What is the matter about? Okay. Also, in view of the order dated, I the matter, no affidavit in opposition has been received. Where is the affidavit? You are not filed affidavit. Okay, okay. So taking into account the order dated 22/9/2023, this court directs the response 22/9/2023 in IAC 3010/2022. This court directs the respondent, the registry to list the instant writ petition for admission immediately after the winter vacations.
My lord, it is the last week of January, it will be better.
It's okay. After the winter vacation, it may come after 4 years.
Okay.
Immediately nullity after the winter. Hmm.
They-
Oh, that's my, this matter. What that?
they
You have
filed
any
an
case?
affidavit. They have filed an affidavit.
Yes.
In that affidavit, Lordship has stated that my promotion was being done as per the office memorandum dated 6/4/1990. And that was not subsequently amended. That is at page 91.
Affidavit,
Affidavit by the financial. Respondent number
Commissioner of Taxes. What do they say?
page 91. Lordship may kindly tell. The above
Careful
office-
provision of the money, it appears that the mainstay of the statement is the rest of human and cannot comprehend independent Indian, hence changes of the human and hence that changes in made between view of the petitioner has been promoted from grade 4 to grade 3 by the then preparing first without having a very rightly done. Huh? So anyways, tell me one thing. If you are not entitled to, you have to job goes. Otherwise also. How much? That other person is senior.
Maybe Lordship, but there is a direction of this court in my favor also.
No.
On earlier occasion, I filed a petition, Lordship.
Maybe
And
this
therein,
court doesn't
Lordship,
find.
Lordship may kindly peruse that order once, and there was a direction to the department in that order is to
Where?
Lordship, that order is annexed to the release petition itself. Page 79. There,
Yes.
the relevant portion, Lordship,
Ah.
the page 79. Considering the submissions advanced by the parties and upon perusal of the order produced dated 25/8/2017, the writ petition is disposed of with a direction to the respondent authorities to consider the case of the promotion of the petitioner to the post of LDA as per rules and as per his stand in seniority as and when the post is being filled.
So?
He was to be given his position in terms of seniority, but the department did not consider that logic and was promoted prior to that.
Did you make in this petition whether that person was a party?
No, he was not a party.
Then
This
what
was
this
an
type of
independent
orders?
direction, Lordship, but
Mr. Sharma, these type of orders hardly make any difference.
the fault of the department, Lordship. I-
No, this is not the fault of the department. It is absolutely the fault of the
then
department for giving you.
Subsequent developments have taken place and juniors to me were promoted without that qualification.
Enough,
degree.
enough. This is a good case for filing, imposing costs, for unnecessary delaying the matter.
I am here, Lordship, because my juniors who were without that degree, Lordship, were being promoted, Lordship.
So what?
Because the guidelines, the office memorandum give debate.
You challenge those? Why you are not challenging those?
I need not challenge those because the
Then why
department
you are
has
not
itself-
challenging means? How can you get it here?
Because the department have itself stated. Lordship,
Department has
that-
given it, then in view of this particular repetition, they stand out there. You challenge this if it has been you as senior to them.
That the office memorandum has not been subsequently amended.
Not
or-
necessary. It follows from there. Isn't it, Mr. Goel? He's senior. Obviously, he will get it.
Maybe, Lordship, but then my seniority was to be given by the department, Lordship, but they did not give it. Lordship.
They didn't, you have not, no, Mr. Sharma, you are not the writ petitioner. You are not the writ petitioner. Otherwise, for 2 counts, you don't get it. Even if we take your ground to be correct, then also you don't get it. You are not the writ petitioner therein. I would have understood you were the writ petitioner, you are assailing this. Don't try to Means on the basis of standing on the foot of a review petitioner, you are just a respondent there.
With respect to that observation, to revert me back to the position of
Very good. It should be. Because otherwise, if I am not giving it to that particular person, how can you get it? When he has put the challenge to you.
the department has itself said that my promotion was being done as per the office memorandum.
No.
Yes, sir. Take on the page 92, Lordship.
What do you want now?
Lordship, at least my position of that.
No, that too is not possible. What do you want? You may at best say that don't end my 2023 with a dismissal. That is the only thing you can say, nothing more than that. Dismissal too, there's no quarrel. I'm not going to hear to all these things. Dismissal is there. I may give one thing. In your petition, in view of that, if I hold it, yes, you have made out a case, I will ask them to appoint that petition. Reversion is right, Lita. That too, which do you want? You want to do some favor to the earlier petitioner because of whom you got reverted?
I have filed a reply, Lord. Therein I have categorically stated that there are vacancies to accommodate.
I am not there. You have not passed out the yeah, then how can they do so? Absolutely. Nowadays, in every case, the judicial assistant has to be a graduate, and now you want this court to say that they should not. High time. At the request of the Learning Council for the petitioner, matters can adjourn to be listed after the winter vacations. We'll finish it on 9th. 9th is the last date. Before Uruka, we have to finish this. At 2. No, 9th is a Thursday. We'll finish it up. At 2.
Hey, Lord says number 34. Lordship, para 21. My lord, the address and
Oh, has been abolished. Where is Mr. Gogoi? What happened? What have you done? The GAD was deciding that about the arbitrator thing. Have they done that? Have they appointed somebody? No, Mr. Gogoi, kindly understand you and who is appearing for the revenue. Yes, kindly think about something which is going to happen out here. If you are not going to do that, this will lead to a floodgate of litigations out here. When there is no third, they don't have the avenues under 3G5.
I would also, it's a statutory post, my lord, it cannot be laying vacant for so long.
Huh?
My lord, this post of arbiter is a statutory post. My lord, it's not laying vacant for so long. So, my lord, a direction may be given.
No, get your thing done. Appoint somebody. No, it's not a question. Anyway, it has to be a person. You can't just make it the revenue department. It has to be a person of a higher thing, something like a commissioner to the revenue, because then only they can sit over that. And also, you have to give it to a person who can do it. Something like a board of revenue chairman, because this is very much required. There are so much of litigations which is coming up. And that person also, arbitrator also, in view of the Arbitration and Conciliation Act, has to have the technical know-how to decide this, not a mere thing like what are the other things. Do something. We'll have this on Thursday. This is the matter again on Thursday, on which date
Okay.
Mr. B. Gogoi and Mr. Appearing for the GAD, as well as the Mr. S. Dutta appearing on behalf of the Revenue Department, shall apprise this court as to whether the government of Assam have as have taken a decision as to who should be appointed and who should be given the responsibility for the purpose of appointment as an arbitrator for the purpose of deciding disputes coming within the ambit of Section 3G(5) of the National Highways Act 56. The registry shall show the name of Mr. B. Gogoi as well as Mr. S. Dutta in the cause list. Your name will be there. Just you give that. No, their names I'm putting it. I don't put here. You are not it. You appear whatever. I'm not. I'm only on concern with it because with this case, if I'm not going to, a floodgates of litigation is coming up.
Daily.
It will have a far-reaching consequence. List the matter at 2. Will be taken up at 2. Yes, Mr. Roy Chaudhary, whenever the matter is called, you are not there. You are always ill, not well, or whatever may be.
I'm extremely
This,
sorry.
this type of filing of a review petition and then not to be present on all occasions doesn't
I'm
look nice.
extremely sorry, Malad.
Then
194, Malad. It was our fault, Malad. I accept it, Malad.
Then-
The council was not there, Malad. Only that is retirement benefit. They have filed an affidavit. Malad. They have filed an affidavit stating that, Malad, we have got some kind of pay commission, 7 pay commission amount, and others, they have filed an affidavit. Some instructions, Malad, from the client, Malad, as because the affidavit filed by them. Some instructions.
tell that, but don't take the adjournment.
Malad, I will.
And Mr. Roy Chaudhary, kindly don't spoil your reputation before this court. If I get an impression out there that every time you say, for the purpose of moving a motion out there, you are very much available, but otherwise, when the matter is there, you are not. Obviously, then it would affect your thing. We have certain discretions which may not. I'm making it very clear to you.
Malad, I'm going down my head, my lord. I'm sorry.
Don't, next time, I don't expect this type of.
Malad, definitely. Definitely.
So, in view of this affidavit, you want to take some instruction.
I'm sorry, Malad. I'm
Mr.
extremely sorry.
Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner, review petitioner, seeks for an accommodation to obtain necessary instructions in view of the filing of the affidavit on 12th of December 2023 by the respondent numbers 1 to 7, 1, 2, 3, 4, 5, 6, 7, in the review petition. List the matter again on 10th of January 2023.
Malad, I'm extremely appointed. I'm sorry.